This is the third part of PR law of this recording. So I realized my last couple of words from part two towards the end was cut out. So what I was trying to say was that with misappropriation of personality, you just need to make sure that you get permission and or you pay license fee. So if you do that, then you can avoid this situation. There are several government agencies or organizations that you need to know as a PR professionals. Um, they have certain guidelines and regulations that pertain to public relations. The first agency is called Federal Trade Commission, FTC. And so FTC, they regulates against deceptive and misleading advertising. They also, FTC has this rule that allows for room for reasonable exaggeration in advertising, which is puffery. It means that if you exaggerate it a little bit, reasonable exaggeration, in other words, reasonable people will know it is exaggeration. Okay, so I actually have two videos here. It's ads. The first one is a deceptive ads and actually got a lot of complaints. And the second one about opera, that's a reasonable exaggeration. You can tell. Reasonable people will know that can't happen. So it's called puffery. I will post those two recordings, uh, those two ads right under the recordings, so you will be able to see those ads. It's difficult to play it in the recording. Sometimes the sound doesn't come out right, so just um, for the sake of certainty, I'll just post it there. So make sure that you will be able to see it. Um, Another responsibility that FTC has is that they have jurisdiction over product news releases and product publicity. So that's exactly the job of PR people, news releases, publicity. So that's why FTC is uh, some agency that you will definitely need to know. Um, there are also some FTC guidelines regarding publicity. I don't have it on the slides, but I'll go over it, and then you just need to be aware of those guidelines. Okay, so there are nine of them. First, information is accurate and can be substantiated. Two, stick to facts and don't hype the product by being non-specific and ambiguous. Three, make sure celebrities actually use the product. Four, watch the language. Five, provide proper context for statements and statistics attributed to government agencies. Six, describe tests and surveys in sufficient detail. Seven, remember that a product is not new if only the packaging has changed. Eight, when comparing your product with competitors, make sure you can substantiate your claim and avoid misleading and deceptive product demonstration. So some of the points we have already talked about before, but there are some things that we haven't mentioned. Um, Another government agency that you need to know is Securities and Exchange Commission, SEC. So they also have some regulations that the PR people should know. Um, the book listed four of them on page 123. Um, So the general guidelines are that first, full information must be given on anything that might materially affect the company's stock. Second, timely disclosure of major development must be made. Three, disclosing information in a fair manner to ensure that all investors receive financial information from a company at the same time. And lastly, inside trading is illegal. So this is a case where, as a PR person, you have some inside information about the company merger or stock price change or something like that. Um, then you tell your relatives or friends, hey, this is going to happen. And then they made some, even if it's not you, but because of your information, they went ahead and made some purchase and made some money. That's inside trading. That's illegal. So if you are caught for that, you'll be in big trouble. Martha Stewart, I don't know if you guys know her, she actually was in prison for a few years because of inside trading. Or even though she's not public relation person, but inside trading is illegal. And for PR people, because you have some information the public might not have. So um, as public relation people, you should especially be careful. Um, there's another law I want to talk about. The book didn't talk about it, but it's important under this context. It's called the Sarbanes-Oxley Act, which was created in 2002 as a reflection to a number of major corporation and accounting scandals. Because of those scandals, some people, some investors, and also company employees, their investments or their retirement funds disappeared overnight, and nobody will claim responsibility. And so the point of this law is first to increase investor confidence in a company's accounting procedure. CEOs and CFOs must now personally certify the accuracy of their financial reports because the scandals happened and some CEOs, CFOs, they say, oh, I don't know about that. So completely try to shed the responsibility. And finally, they're subject to criminal proceedings if they're not accurate. So this will be the last slide regarding corporate employee free speech. And so we all know First Amendment right. As individual, we have that right. However, commercial speech, so like advertisings, any kind of um, promotional um, materials, they do not have the same First Amendment protection. They do have some kind of protection, but not the full protection as we as citizens have. Corporate speech is when sometime corporate, like CEO or whoever, the leaders will make some kind of comments. They do have the First Amendment right. It's different from the commercial speech. Um, because they see it as a company, that's company mission or company philosophy. Some people see this corporate speech has a First Amendment right protection. They see that as unfair because they feel corporations, they have unlimited resources, they dominate information. So they do not give activists or consumer groups a fair chance to fight against them. So there's controversy there. Um, regarding email employee employee email, Many companies contend that they have the right to read the email of employees. So employee privacy is oftentimes a hot button issue, and the trend line is for increased monitoring of employee email by employers. Companies contend internal email systems are company property for official company business. So employers are concerned about being held liable if an employee posts racial slurs, engages in sexual harassment online, or transmits sexually explicit jokes that may lead to a hostile environment. Other aspects include whistleblowing and the protection of an organization's trade secrets. To maintain trust, an employer should carefully spell out company rules about email, for instance, etiquette, punitive possibilities, etc., during employee orientations and maintain communication at various points. Similarly, with employees surfing the internet, it has similar issues. Sometimes people sharing the same office space see the other employee surfing the internet, see some content they don't feel comfortable about. And so the company might face potential liability because they let the employee surf the internet that other people might not feel see the content they feel not comfortable. So again, companies should spell out rules about surfing internet. At work, you shouldn't be doing that anyway. However, I'm sure people do that, so the company should have rules about that. Finally, employee blogs. If you, in your blogs, you mention in personal capacity, okay, in the company capacity, of course, there are rules and regulations, but if it's personal capacity, if you do not mention the company names and just personal opinion about certain events, issues, should be fine. However, there are numerous cases where employees got into trouble because they posted something that the company feel it wasn't right. It's very controversial issue, so need to be very careful about what you post online. Social media, as soon as you post something, it exists. You can't take it off, so you need to be very careful. The book also talk about sponsoring an open house or promotional event. I don't have slides for it, but on page 112 to 113, it talks about some of the legal aspects PR person should be considered when sponsoring an open house or promotional event, because that's PR people's responsibility. So I'll just go through some of the key points that PR people should know when sponsoring those kind of events. There are 9 points. So first, public safety, including medical help and officers to help with traffic flow. Two, liability insurance is a necessity. Three, events with food and liquor require permits from public health departments and/or state alcohol boards. Four, outlining and marking a well-defined tour route. Five, providing an adequate number of restrooms and sufficient parking. Six, training guides in first aid and knowledge of the organization. Seven, staffing a central information booth. Eight, preparing adequate maps. And finally, having contingency plan if there's an accident or injury. So that's the end of my recording for the legal aspect of chapter